What really happens during the discovery phase of a lawsuit? Hi, I'm Tom Friedman. I'm a lawyer in Nevada, and somebody files a complaint against one person. That person files an answer in response to the complaint. That starts the lawsuit, and once the lawsuit begins, generally you move to the discovery phase. And the discovery phase is really figuring out all the facts relevant to the case. So there's different stages to it. There's a written stage, if you want to call it that, where one side will write something called written interrogatories. Essentially, interrogatories is a fancy word for questions, usually from lawyers. So you'll fill out interrogatories to the other side. Where were you going at the time of the accident? Who were you with? Are there any witnesses? What are your medical claims? They're going to be written questions that are going to go to the other side, and the person on the other side, if they've got a lawyer, the lawyer is probably going to fill it out all for them. They'll help answer the questions and sign it, and then you'll get it back. There's also something called request for production where, hey, give me a copy of the insurance policy. Do you have any photos of the scene? Things like that. You're asking for tangible documents. And then finally, there's something called request for admissions, where you'll send something like, hey, admit that you had back pain prior to the motor vehicle accident, or whatever it is. So all of these written questions are generally filtered through a lawyer on the other side, so they're going to be maybe less helpful than they would be when you get them back, but still everybody does it. It's an important part of discovery. Now, a second part people use in discovery, if it's a case that has a higher perhaps value to it is the right word, is experts. If you're in a car accident case, you might hire an expert to go and download the EDR info, the black box from the other car. If it's a slip and fall, you might want to have an expert go out there and look at the coefficient of friction on the ground. So in certain cases, experts are very important. If it's a construction type litigation, you're going to want to have construction experts go look at it, get their analysis, do a report, and all of that's going to drive your case along. Now, there's also a part of discovery that involves depositions. So a deposition is asking questions to a person. You're going to look for witnesses. If it's a slip and fall, a product break, you're going to say, okay, who was there? You're going to want to get a witness and ask them questions. You're going to take the deposition of experts if they're in the case. If somebody treated with medical issues, you're going to probably want to depose the doctors. And what a deposition is pretty straightforward. There's a lawyer there that's setting the deposition, and that lawyer is going to ask questions to whoever the witness is, and generally the witness is going to have a lawyer with him or her, and that lawyer may object sometimes, maybe not. There's going to be a court reporter taking everything down that everybody says. It's going to be turned into a little booklet, and that booklet will be evidence that can be used should the case go to trial. So it's informal. There's no judge, there's no jury, there's no bailiff or policeman, anything like that. It usually just takes place in an office, but it is an important part of the discovery process. So the idea for discovery is to get all the facts together and all the expert information together so people can make a rational decision. And a lot of times what will happen is once discovery has been completed, the people will get together, they'll go have a mediation, or they'll informally try to work things out. And a lot of cases get resolved through this informal settlement or mediations and don't actually have to go to trial. So if you've got any questions about discovery, please feel free to contact me. Thanks very much for watching.